Good evening. This is a meeting of the Athens Board of Zoning Appeals. The time is 7:03, and the date is August the 13th, 2013. At this time, I'll call the meeting to order. The board consists of 5 members and 2 alternates, the alternates taking full part in the discussion and becoming a voting member in the absence of a member or when a member abstains for conflict of interest. Present tonight are Lisa Carson, John Gulsey, Joan Kornowski, and Kay Towsley. I'm Betty Hollow, and also present are Zoning Administrator John Paskey and our Secretary Paul Eschenbacher. The board operates under the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard, and anyone wishing to speak in opposition will be heard. If necessary, the appellant or representative will offer concluding summary or rebuttal remarks. Testimony from the floor will be closed. The board will deliberate and render a decision. According to Athens City Code 230703B, the board has the power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to City Code Section 230910C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. First, practical difficulty and undue hardship because of extraordinary or exceptional circumstances or conditions pertaining to the specific piece of property, a literal interpretation of the regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Number 2 is exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such a variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of the property for which the variance is sought, one or the other, or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There is only one case on tonight's agenda. The case concerns the property at 27 South May Avenue. The case is 1309V, and we will ask the zoning administrator, our secretary, Mr. Eschenbacher, to explain a bit about this particular case.
What the property owners want to do is, if you have your diagrams there's an existing garage there. They wish to tear most of that down while saving the one wall that's parallel to the alley, and use that wall as a basis or part of the new proposed garage that they wish to wish to put up, which will be bigger than the old garage. Thus, that's why we have the overage on the lot coverage, and that's why they wish to have the rear setback of 0 feet, because they want to keep that wall
Okay.
that's there.
And they want to keep the wall in order to have the 0 setback, I assume.
Well, I think mostly they just want to keep the wall to use
Okay.
it for the
All right.
new
Okay.
garage.
All right. Anything else we need to know before we swear people in?
I don't think so.
Can
Unless you
I-
have
Okay.
questions?
Questions?
Yeah, I do have a question. I think when we discussed this down at the code office, Mr. Eschenbacher, it was about the accessory structures, and I looked it up in section 23. So it is that any accessory structure shall be located closer than 5 feet to the side or rear lot lines. It says 230311A1. So I'm wondering if we shouldn't include in this, on the application for 123 unit residence use permit that we have in our packet, it says that what is required is 4, but really 5 is, and they only have 4. So perhaps we should include in these proceedings.
There's a section in there as well that also states or 10% of the lot width, and the lot's 40 foot wide. Now, that would be for the primary structure, and we talked about that in our office. It's the first time we really encountered it on accessory structure, but I figured it would apply there as well. So, with a minimum of 4 feet. So that's why we did not,
I'm sorry, John, I don't know what you're referring to.
that's why we didn't incorporate that part in, if I may, Paul. Bear with me, though.
Okay. I mean, it's a minimal thing, it's just that it was set
Right.
straight then with the code, and since they're doing this, it's only a foot, it's just that the form said 4 and the code says 5.
Setbacks.
I would probably also think that even if it does work out that we've done this with the 10% rule, in other words, since the lot's 40 feet wide, instead of having the 8 and 20 side yard setback rule, you only need to come up with 10% of the width of the lot for, so they, like you said, they did that for principal structures, and they thought they should do
Right.
it for accessory structures. I guess what I'm getting at is, even if we figured it out properly with the 4-foot thing, I don't think it would cause any harm to put it, what you suggested in as an added part of.
Right, I think it's
Yeah.
minimal, and then, without then having somebody to go look through and find that 10% if it's only,
230303B
230303B.
states that no structure shall be constructed on a lot containing less than the required area unless the owner can demonstrate that the structure will have a minimum side yard of 10% of the lot width, but in no case less than 4 feet on interior lots and 12 feet on the side yard adjacent to any street. So that's where we come up with the 4 feet and, or the 10% because it's a 40-foot wide lot. So-
Okay.
except that just refers to a single-family structure as opposed to, is that not the structure they're referring to? It's just a...
I know what you're saying. It's the first time we've encountered it. I followed this one. If we want to go ahead and include it in, it's something I think we need to think about in the future as to which way, if accessory buildings in R1s or for single-family lots would fall under the same requirements as the actual use itself, because there, for example, on the side yard part where it says 12 feet on side yards, but if the side yard, if it was on a corner and the house was 6 feet away, we'll let that garage go to 6 feet away because it's an established setback line.
Right, and that's what it says in the code.
Right.
Right, so that's stated.
So the question is, why do we treat accessory buildings then the same way as we're treating residents? So it's one of them interpretation things, as to which way you want to interpret it. I interpreted it to say that 4 foot was permissible, but if we want to include it in as saying part of the variance, that's fine by me as well.
Okay, so we're really saying, instead of saying where 5 feet is the required minimum, it could be 4 feet. Is that what you're saying?
Right, because that would be the rear, too. So you're talking,
Yeah.
Rear yard
Right.
setback of 0 feet?
Well, in this case, the rear would be 4, well, no, the rear would be, because the lot's 100 and some feet deep, so they wouldn't
Okay.
apply, so the 5 foot still comes into, on the rear.
Okay, so we're leaving that as it is, and we're really talking about a remaining wall that actually has 0 feet.
The rear setback is 0 feet where 5 was required.
Yeah, okay.
The
All right.
one Ms. Kransky's talking about is the 4 foot where should we be granting a variance for 4 feet versus 5 feet as well? And that's the interpretation of the code, which,
Okay.
we just discussed.
Okay. All right, any other questions
Nope,
before
that's
we
all I had.
proceed? Anybody else? Okay, anyone who wishes to speak needs to stand and be sworn or to affirm that you will tell the truth and nothing but the truth. Do you so affirm?
I so affirm.
Thank you. Okay. In that case, I think we are ready to proceed. So the appellant, do we have an appellant?
Steve,
That's him, yes.
are you here just to speak as a witness, not as a... Oh,
Yes,
okay.
so we don't have an appellant present.
Was it Steve Crossley, is that his name?
Well, the
The owners
applicant is,
indicated that they weren't going to be here
Oh,
and that
okay.
they were going to appoint somebody.
okay,
I
Well-
thought they said they were going to get the contractor to speak, Steve Crossley.
okay, we don't have him.
So if Mr. Crossley's in the neighborhood and watching,
Hurry up.
hurry up. But if
Okay,
not,
so how do you recommend we proceed?
that's up to you guys. If you want to continue it, if you're,
Opinions, please?
I'm comfortable with continuing it,
Tonight or the next meeting?
No, right now.
Right now? Okay, let's decide. Continuing right now. Hold up your hands.
Okay.
I'm confused.
Well,
Well-
we don't have an appellant to speak for him or herself.
But we can
or
go
represent-
without that?
Well,
well, I mean,
Okay.
Well, we've always had someone here to represent them.
what I would worry about is
Yeah.
if you would go ahead with the case and then refuse it.
Yeah.
I would
Right.
think the appellant would have a right to say, we didn't have proper representation.
Well,
So are
it's
you-
their own
Well, that's
issue.
true,
That's,
but-
they should have been here, so that's.
But
I can't-
if they appointed somebody for him and he didn't show up, it may not necessarily be their fault if they're out of town.
So are
But
you-
that's up to you guys to decide. I'm just saying.
all right. All
I
in
thought
favor
continue
of
meant like a
continuing right
continuance.
now?
No.
Speak. We have one person who wants to continue right now.
Well, we
Anyone
could
else?
continue in either way, the next month or now.
Okay, let's see, how many are in favor of continuing next month? Just to
I
be on the
think
safe
next
side.
month, I think it would be safer for
Yeah.
everyone
Okay.
concerned.
Is everybody in agreement that we continue this case until next month when we hope to have a representative?
Yes.
Yes.
Okay,
Okay.
so
So
moved.
did you
Yeah, do
vote
you
along
want-
with that too, Mr. Gold?
Yeah, do you want to get his testimony now, so he doesn't have to come back next
Well,
month?
does that seem like a reasonable idea?
I don't know why not.
Okay. Yes, would you like to come and speak to us? And you should come over here so
Well,
we can
did-
hear you.
I guess you could ask, does he want to speak for, general comment, or
Okay,
against?
do you want to speak for, general comment it?
Speak for.
Okay, so if you will come to the microphone so we can hear you, tell us your name and address for the record, please.
My name is Tim Vickers, and I live at 102 Elmwood, diagonally across from the residence in question.
Okay. So tell us why you are in favor of this variance for them.
As I understand it from, I haven't seen the diagrams, but it doesn't seem like it's going to be that much different from what's already there, as far as they're building upon it, but it doesn't look like it's going to get that much closer to the alley in question. As I said, I haven't seen the diagram, but so as I understand it, the existing wall that they're talking about, tearing it all down, but using that existing wall is, as it is stands now, is going to be in the same place, so it's not going to be
Yes.
closer to the alley.
Right.
Right.
So-
It's as close as it can get.
It's already as close as it can get, and I think I'm in the same situation diagonally across the way, and they've done nothing but help improve the neighborhood. If you know that corner, there's been some problems, and anything and everything that they've done has only helped me and my family. And as I see the proposed looking at it now, it doesn't seem like it's going to change things much as far as the city's concerned, as far as getting too close to the alley or certainly not any closer to the street. So I don't see it as an imposition that way as far as, meeting the conditions of the variance required, or whatever the technical terminology is. I don't see any detriments to me or anyone else in the neighborhood. And as I said, anything and everything that they've always done to their property has only helped.
Okay. So, in essence, they're only encroaching on themselves and not on anyone else?
Yeah, that's what I see. Another question that didn't come up, that was in the letter that they had asked me about, was the 33% rule.
Okay.
That sounds, I guess that's not much of a question here then.
Well, it's the maximum allowed is 30%, and they're going 33. So.
Okay. And I think they could probably tear up part of their entrance sidewalk and make up the difference there. It seems like a very small difference. But it seemed like what they were asking was not very much, and I give my unqualified support for what they're trying to do as a citizen and as a neighbor.
Okay. Anyone have any questions of Mr. McVickers? Thank you very much.
You're very welcome.
And now you don't have to come back next month.
Right. I'll try to hang
I
on
was
to
going to
your
say, you got to
testimony.
represent the
Paul
property.
will. Okay. We do also have some other letters of support from neighbors, but we can hold those till next time. And so, we'll continue this case. Mr.
Did you want to go ahead and vote on the minutes?
Yes, we do. Yes. What about the minutes? Can we approve those?
Just one slight correction. I'm
Okay.
sorry, I should have looked at them earlier. Under the findings, number 5, instead of saying sign light, it should say sign blight.
Okay. Mr. Eschenbach, I'm sure will be happy to correct that. So shall we approve these minutes as presented, except for that one correction?
I move to approve the minutes.
I second.
Thank you very much. So approved. Anything else that we need to discuss about this case or anything else? We're adjourned.